the abolishment of common law marriage in Canada. Today we're going to be talking about the different marriage laws in Canada. We're going to cover the following topics: marriage, common law marriage, divorce laws, and prenup and cohabitation rules. There is currently a stigma around weddings in Canada. When most people get married, more focus is put on the ceremony and the party afterwards, and forget that the marriage is really the legally and formally recognized union of two people as a partner in a personal relationship. According to Statistics Canada, the average Canadian in 2017 spent around $42,000 on their wedding. People seem to think weddings need to be a big party, but it's up to the couple to decide how they'd like to celebrate their day. Getting married can be as simple as getting a marriage license and heading down to the city hall to become legally married. To start, we're going to cover some of the main differences between common law marriage and legal marriage. Common law marriage is when you are in a relationship but you aren't legally married. This means that you have been living together for over 3 years or over 1 year if there's a child involved. The only difference between legal marriage and common law marriage is when you have a legal document saying that you are married by the law in Canada. Granted, religion and ethical reasons being legally married is better, but it's up to you and your partner in the end. Now we're going to be talking about marriage laws. When getting married, you are making a promise to each other and in a religious circumstance to God. You receive a legal document saying that you are married. One of the main points when saying vows is till death do us part. Once that is said, that means you are promising to be with that person until one of you dies. In Canada, when you become married, it is essentially like you are being recognized as one whole person instead of two separate individuals. This means that you can file for your taxes together, apply for one another's health benefits, and even if you end up on trial, couples who are married to each other cannot testify against one another in court. In Ontario, the person who performs your marriage ceremony has to be licensed by the government. You can be married in a religious ceremony performed by a priest, a pastor, a rabbi, or in a civilian ceremony with either a judge or a city clerk. If the marriage falls through, then it leads to divorce or separation.
Divorce and separation. Divorce is becoming more and more common. Even growing up, many of my friends and members of my family were either experiencing divorce or knew many people going through a divorce. Around 40% of all marriages end in divorce in Canada. In order to be eligible for divorce in Canada, you have to prove to a court that your marriage has broken down. This can be done in one of 3 ways. You have been living apart for more than 1 year, your spouse has been mentally or physically abusive towards you, or you or your spouse has committed adultery. Usually the majority of divorces come to be for the first reason. After a couple gets a divorce, all assets are to be split up equally between both members of the marriage. Married couples can sign a prenup before marriage to avoid the equal split of all assets. The main difference between getting a divorce and being separated is the fact that you will no longer be living together. People must be divorced if they wish to remarry. If remarrying isn't in the picture, you may just stay separated. You don't need a lawyer to be separated, and there is no paperwork proving that. It is a choice to make between the couple. Now moving on to prenuptial agreements. Around 9% of Canadians have prenuptial marriage agreements. This number is shockingly low. We personally think a prenup is a smart idea because it protects each individual's assets in a marriage. However, signing a prenup is like inferring that your marriage will come to an end before it is even starting. That does not seem like a healthy way to start a marriage. Unlike married couples, common law partners can dissolve their relationship at any time. However, in most situations, it is never that easy to walk away in the case of common law separation. It is very confusing and difficult compared to a marriage divorce or separation because unlike in marriage, the division of property split equally is not guaranteed. For common law couples, a cohabitation agreement can be used to deal with property rights. However, like prenups, they are rarely used.
Now talking about problems when it comes to common law marriage. The law is already very complex and blurred in many areas. Common law marriages only add to this confusion. The biggest myth about common law is that it's easier to walk away from the relationship when it ends. However, when it comes to the separation of assets, property, or even child custody, there's usually no written agreement. This makes the separation process more complicated and more expensive when it comes to hiring legal help. Getting married allows for all assets to be split 50-50 no matter what when a divorce is in place. Although this may not seem fair in certain cases, it makes the legal process easier and requires less legal help in the end.
Why is this a problem? The main issue with common law marriages is that even if you meet all the requirements to be considered a common law couple, there is still no presumption that the marriage existed in the eyes of the law. So marital rights are never fully guaranteed. Therefore, in the case of a breakup, not each party of the relationship is guaranteed equal benefits. Common law marriages can leave one person extremely vulnerable when it comes to the division of assets. It is obviously not fair in all cases of divorces that assets are split 50-50, but it is even more unfair to leave one party of the relationship completely and empty-handed after the breakup of a long-term, serious relationship. Although the two couples on the screen may look the same, dating and being married are two very different things. This is our proposal for reform. We believe that common law marriages should be abolished, and in Canada, a couple can either be married or remain a couple. Common law marriages are insufficient and very confusing. In this day and age, many people have stepped away from religious values and are leaning towards more common law marriages to avoid the whole big marriage idea. Don't get us wrong, we do believe that marriage is worth celebrating and rejoicing over, but we also think it should be up to the couple to decide how they wish to celebrate. Religion plays a big part in the reason many couples decide to get married. However, as Canada evolves, we are becoming a more secular country. This means that Canadians' belief that religion and religious authorities should be looked at for guidance is declining. Instead, many Canadians are looking to more social, political, and cultural influences whose expertise are not religiously based. Because of this, many couples have decided to live in common law marriage. Although this may seem like a good way to keep religion out of the marriage or relationship, there is another way to do it. In Canada, you can get married in a religious or civil ceremony. This allows for couples to get married based on their own values and avoid implicating religion into their relationship if it is not wanted. In support of the reform, there are already a superior amount of couples that are married than couples living in common law relationships in Canada today. According to Statistics Canada, 78.7% of couples were married and only 21.3% were living in a common law relationship. One of the big reasons we believe people shy away from marriage is the fact that they have to get divorced if the marriage comes to an end. However, as mentioned before, the breakup of a common law marriage can be even messier. Nobody steps into any relationship with full guarantee that it will all work out. The truth of the matter is there is always going to be some uncertainty. Being married is like having a safety net in case things go unexpectedly. Marriage allows for one to be legally protected in the case of a divorce or death of a significant other. Like divorce, death is pretty much unpredictable. If a couple is living in a common law relationship and one of them happens to pass away suddenly, the only legal way a common law partner has access to their assets is through a will. This is because, unlike marriage, a common law relationship does not have legal standing. Even more concerning is that according to a poll conducted by the Angus Reid Institute in 2018, 51% of Canadians did not have a will in place before the pandemic. Marriage is legally recognized, and in the case of death of a partner, the surviving spouse will receive some or all the assets unless specified otherwise in the will.
Access to justice. Removing common law marriage allows for all couples who choose to get married to be treated equally in the eyes of the law. Common law marriage does allow for couples to enjoy certain marriage benefits, but does not allow them to be fairly protected by the law. Removing all common law ideologies will allow for all married couples to be treated equally in legal proceedings.
Canada has already made the access to marriage very easy and accessible to anyone who chooses to become wed. Common law is a very confusing and unnecessary term that needs to be abolished. People need to be informed of the legal protection at risk by remaining in a common law relationship and choosing to not be married. Canada should abolish common law relationships and allow for couples to be known as married or just a couple. There is no in between.